Stephen, thanks for joining us today. We are going to cover a very popular topic in the estate planning world and in the especially in Florida, and that's the how to avoid probate and the truth about how you can avoid probate and what strategies we can use in Florida. So, welcome. Thank you for being here.
Thank you. Thank you for having me.
So let's dive right in, and first lay the groundwork of what is probate and why do we want to avoid it in the first place. So for listeners that are new to this topic, what does probate mean in Florida?
Yeah, so probate in Florida, it's a court process. Florida statutes require that you hire an attorney to take you through the probate process. Um, and so what it basically is, it's the true definition is proving a will. So therefore, if you have a will-based plan or no estate plan whatsoever, and you pass away with assets titled in your individual name, then the probate process does two things. Number one, it determines creditors. And so it gives the decedent's family the ability to identify the creditors, but also sometimes identify unknown creditors in order to shorten the statute of limitations on the creditor's ability to try to attach the assets of the decedent.
Okay.
The other thing is it retitles assets into the name of either the no will, which means that it's intestacy statutes, and that's how things will be distributed, or by way of your will, how you set it out in your will.
And so why do people want to avoid it?
It's expensive, it's lengthy,
Hmm.
um, and also basic probate, you're leaving yourself to the state's rule book, what I call the state's rule book, which means that it has to follow the statutes. So in that, the process is when you petition the court to have the person who you want to be personal representative,
Hmm.
um, that's usually about a 45, 60-day process before you have the person who you've designated to be able to act for your estate. And so therefore that often gives people a lot of heartburn, a lot of concern of how am I going to pay the bills? How am I going to pay the utility bill? How do I access the assets if it's a surviving spouse or even children who are relying on the decedent? How are they going to access assets in order to help them live? And so from there, it is we publish in the newspaper that the person has passed away, what's called a notice to creditors. And so any unknown creditors have 90 days
Yeah.
in order to file a claim against the estate.
Okay. So beyond money, then what are some of the emotional or practical burdens that probate can place on a family?
It's time.
Mhm.
Time is a lot of it. Um, once a decedent passes away, you want to have time to grieve. And sometimes that probate process, because it takes so long to go through, it sort of prolongs that grief because you haven't quite closed, that chapter, so to speak, because you still have these things ongoing. The other thing is it provides, like I said, provides a forum to fight.
Mhm.
So we've had it to where, somebody who was written out of the will because they were no longer close to the family member, they wrote something basically on with crayon and put it into the court, and that was enough to stop the probate process for 6 months, in order for the court to hear what that person's concern was and things like that, and go through that process. So that increased the cost even more so
Mhm.
because of now it's more of a contested probate rather than just a standard probate. So those are two of the biggest things that we see is, um, the time and then having an open forum for people to come in and fight.
Mm. Mhm. So if we want to avoid it, you already mentioned that the gold standard in a way for avoiding probate is the revocable trust or revocable trust, however we want to pronounce it.
Right.
Um,
Either way,
so why is that considered the gold standard?
because of the fact that, um, in that we can work in plan A, plan B, plan C, plan D, right? And so sometimes people think, I'm going to gift away my assets before I pass away, or I'm going to rely on payable in death on all my accounts, and that's what I'm going to rely upon. The problem with that is unintended consequences.
Mm,
So maybe the person you designated predeceases you, and then it drops down to the grandchildren who are minors. Those who are under 18 who receive a inheritance over $15,000 has to go through a guardianship.
mm,
So there's another added layer of cost. Also, in that there's an annual accounting with the court. You have to petition the court anytime you want any sort of money out of that guardianship account. And then at 18, that 18-year-old receives a lump sum of money. I don't know how you were at 18,
mhm.
but giving me a lump sum of money at 18 was not a good idea. And so therefore, having the trust, we build in all those contingency. If this person passes away, it goes to these people. If those people are under, we usually say about 25. Um, if they're under 25, it's going to go into a trust for them to help provide for them, right? Because that's what the grandparent may have wanted intended. Um, but is there a protected manner for them so they can't just blow it because they're 18 years old? There's no accountings with the courts. There's no extra expense for a guardianship.
Mm,
So we work in all these plan A's, plan B's, plan C's, plan D's because of the fact that life happens quickly.
mhm.
People don't like to come into our office, even though we try to make it really comfortable, to talk about death, talk about disability, things like that. And so therefore, that's why it's very important to us that we build in all those contingencies, and a trust allows to do so, but payable and death accounts do not.
Okay. So let's talk about what other, besides the trust, what other avoidance tools are out there. So I know this because I'm still having to do this on some of my accounts. Beneficiary designations. How on bank accounts, life insurance, retirement accounts, how do those help avoid probate?
So those are done because they're by way of contract.
Hmm.
So the contract between yourself and the financial institution is make it payable on death. When I die, pay it to this person. Um, we actually just had one where we have to open up a probate anyways
Hmm.
because the bank didn't file that POD designation correctly. So that's sometimes going to be something we run into. Um, Where it does become a little bit more tricky is in retirement accounts because of the IRS rules and regulations, make that a little bit more complicated and can suffer some tax consequences that you don't necessarily want depending upon the situation. So that can be a trap for the unwary. But that's a that's by way of contract really is what a payable in death is.
Okay. And are there common mistakes that you see with those designations that people should be thinking about with the different types of accounts?
So Um, again, not keeping up to date with those.
Okay.
So it could be a deceased person is on there and then has to go through probate anyways. Um, I've also had it with life insurance where it's a very sad situation, an old Italian couple, and I guess from my understanding, where they lived in Italy, the man should never pre the man should never survive the wife.
Mhm.
The wife passed away and there's a life insurance policy. And to the great dismay, of course, of the family,
Mm.
the father went next door and shot himself because no, he shot himself right before she passed away
Okay.
because of that belief, right? And so he had life insurance, and the beneficiary was, of course, her.
Mhm.
And so then we had everything else, you know, to avoid probate with the trust, but then because of that, that asset had to go through probate.
Okay. Okay.
So it's things like that, just not keeping up to date with those sort of things is how we obviously probate. Or sometimes we see people just say, it's just a small bank account. We're not going to worry about that. There,
Can you go ahead?
there's nothing more frustrating to a beneficiary or to a child to say, okay, everything's titled in the name of the trust, except for this account that has $10,000 and it costs $4,500 to go through probate to bring that out. So that can be
Right.
very,
Yeah.
very frustrating for the children or for the beneficiaries.